The trauma from sexual violence can cause a survivor hundreds of thousands of dollars in losses, if not millions of dollars in losses. I'm going to talk today about two of the ways that the court values these losses and how they can be proven in a civil lawsuit. I'm Natalie Gerry, the principal lawyer with Gerry Law. I help injured people get the compensation that they deserve for their injuries. Trauma from sexual violence can impact a survivor's ability to work in terms of keeping a job, attending work, work performance, and sick days. These types of issues disrupt earning power, and they have a serious negative consequence on the financial well-being for survivors. In a civil sexual assault lawsuit, these types of losses can be claimed for. Scientific studies show that in particular, children or young adults who are experiencing or have experienced sexual violence have a long-term lower income than people who have not experienced these issues. With children who experience sexual violence, it's likely that their income is lower later in life because their educational ability is impaired due to the trauma of the abuse. Plaintiffs who have experienced abuse, especially at a young age, will likely have a lot of time off work or missed time at work because of the trauma. It's very common, and I see this in my practice a lot, that children who have experienced abuse grow up to be adults who have post-traumatic stress disorder. They may have depression, they may have anxiety, they may have trust issues, and they may have issues with authority. And all of these issues can contribute to an inability to earn income as they would have had they not been abused. Economic damages are awarded in civil sexual assault lawsuits for things like diminished earnings caused by the abuse. This can be calculated in two different ways. There are two different approaches that the court takes. I'm going to go over the two different ways. The first is the more traditional way that the courts use, which is a missed time at work calculation. This involves looking at what the plaintiff would have done for employment and how they would have performed but for the abuse, and then taking that number and then looking at their actual earnings and subtracting them to get the difference. For example, if an abused individual grows up and goes on to become a social worker, but they are forced because of their trauma to take 2 years off work, for example, then they would be able to claim for those damages for the time off work, as long as the time off work can be linked to the abuse as a child. Then their yearly earnings would be multiplied by 2 to get that loss. The other way that a court can evaluate the plaintiff's losses for their diminished income is by looking at the failure to reach their potential. Say as a child before the abuse, they had always wanted to be a veterinarian, but because of the abuse, they were not able to complete all of the schooling that is required, and there is a lot of school, and maybe they couldn't complete the courses because of the PTSD they were experiencing because of the abuse or because of other psychological issues from the trauma. In this case, the court would look at what they would have earned as a veterinarian, say, versus what they did earn in the jobs that they were able to have. Then the court could calculate the losses based on the potential income versus the actual income. Now you might be wondering, how do we actually prove these losses in court? And the way that it is done is usually through expert evidence. A vocational expert can be hired to speak with the plaintiff and look at what they would have done as a child if not for the abuse, and they can give a report to the court on what the plaintiff would have done if they weren't abused, so that the court can then make that calculation, or the plaintiff's lawyer will make the calculation of what their potential was versus what they actually attained, so that the damage can be calculated with some precision and presented to the court. The expert will want to look at evidence that the plaintiff has, such as their grades before the abuse versus after. They will also want to look at their parents, siblings, their family to see what kind of education they attained, and then any other evidence of how the child was before the abuse in terms of their career aspirations. If there is any evidence of that, it would be extremely helpful for the expert. In some cases, the expert may be able to look at the evidence, such as if there was the child's indication that they wanted to be a veterinarian and maybe they had pictures that were drawn, or a school project where they had explained what they wanted to do when they grew up before the abuse. And the expert could also look at their siblings and parents and see, and especially if maybe both their parents were vets, or they grew up on a farm and they had that interest. The vocational expert could perhaps conclude with some certainty that yes, they would have gone on and done this career. They would have finished the education and they had enough evidence to show this. In other cases, the vocational expert might not be able to pinpoint exactly what career it would have been, especially if the abuse happens when the child is fairly young and there was no indication of what they would have done before the abuse. Then the vocational expert can look at the general family members, what their intention was, describe like what the plaintiff says their intention was, and might be able to come up with, if they hadn't been abused, they would have attained a certain level of education, and then look at the income for that level of education. So the difference between what the plaintiff might have obtained had they not been abused minus what they actually were able to obtain as income, and then they can take the difference, and that would be the claim for damages for the loss of income. Plaintiffs might be surprised but these numbers add up very quickly. Even if a person was an average student in high school and because of the abuse they dropped out of high school and didn't complete high school, the earnings from a high school dropout and the difference between someone who completed high school, even if it is a few thousand per year, this can add up very quickly in the span of a person's working career. People are working for longer now, and from the time that they would have graduated high school until when they could have retired, this can really add up. Even if it is a few $1,000s per year, this can be a significant claim. I should say here, everyone's situation is different and everyone needs to get tailored legal advice to their situation. What I'm giving here is just general legal principles that won't apply to everyone's situation. This shouldn't be taken as legal advice. You really need to get advice from a lawyer about your situation. This is just to give a general overview. I now want to talk a little bit about how the court approaches awarding these types of damages, because it is somewhat different in sexual abuse matters. With the two approaches, the one with the income loss where it can be determined what the job was. We talked about the social worker who then took 2 years off and the court was able to calculate the losses for the 2 years, versus where the plaintiff's potential was not reached, so they weren't able to earn that income over the years. In some cases in Ontario, the court will have that number based on the first scenario, the 2 years of missed work, but they will take the approach of doing more of a global assessment of the losses. So we'll just give a round number for the losses. And this is a bit unique. The other thing that is unique is the burden of proof in a sexual abuse matter, because in a typical personal injury matter, the past losses of income are on a balance of probabilities. So the burden of proof is 50% plus 1 that these losses occurred, and that's what the plaintiff has to prove. In a typical personal injury case, then the future losses after trial have to just be proven on a lower standard, so a possibility that the losses would have occurred. So that possibility, which is even lower than a probability, is a lower standard. But the issue that comes up is sometimes these sexual assault lawsuits are brought decades after the sexual assaults have happened. happened and after the injuries have occurred. So it is a bit different because even though those losses are past, they are still in the future in terms of after the injury happened. When the court looks at that loss of earning capacity, what the plaintiff would have done but for the abuse, they do so on the burden of proof, which is a possibility that it would have materialized. And this is just much more fair to the plaintiff rather than having to prove it on a balance of probabilities. The Court of Appeal in Ontario has endorsed this approach, and it is somewhat helpful to plaintiffs because it only asks that you prove that there is a substantial possibility that the loss would have occurred. The loss of earning capacity approach that we discussed in the second way that the court can assess the loss to the plaintiff. This is the way that we talked about where the plaintiff would show that they would have obtained a different level of education had they not been abused. This is sometimes used by the courts when they say that they cannot calculate with mathematical certainty what the loss is. So this is a different way of calculating those losses. If the losses can't be calculated exactly, then sometimes the court will use a loss of earning capacity measurement to provide the plaintiff with some compensation, but that won't be as exact as what they would have calculated that they actually lost. This treats a plaintiff's ability to earn income as like a capital asset that has been diminished, so it's worth less because they're not as able to earn income. Typically, the court will award between $50,000 and $200,000 for this type of loss, so it is a different way that's available for the court to compensate the plaintiff. Overall, whatever method the court chooses in order to compensate the plaintiff for their loss of income, your lawyer needs to work with you to make sure that they have all of the evidence presented to the judge in a way that the judge feels comfortable awarding this type of economic loss. Your lawyer will work with you to get all of that evidence to present to the judge. I have another video about the types of damages that you may be entitled to in a sexual abuse lawsuit, so please check that out. It'll be linked below. I also have another video going through various cases showing the types of income loss that were awarded by the court. That one will also be linked below. Please check it out.